For those that don't know us, my name is Rebecca Shepard. I'm here with my partner, Peter Huckabo, and we are tax attorneys. So in addition to being the coolest kids in the room, we have to keep abreast of all types of rules and regulations that affect small businesses and individuals. And the Corporate Transparency Act is certainly one of those new requirements that affects, I think it's approximately 32 billion companies. So we'll get into all of that in a minute, but just to give you a little bit of background about me and Peter, we've both been practicing the same amount of time, each about a dozen years, in working in tax controversy. So what that means is working with individuals and small businesses in a way to get them to be compliant with their tax problems, help them through payroll tax liabilities, sales tax audits, some cases, white collar criminal issues, and all sorts of things that business needs in order to be in compliant with the government. During our practice, when COVID hit, we realized that our clients were going to need more help than some other folks, in that they were one strong breeze away from not being able to continue operations. And so we dug down deep into the CARES Act and helped them through PPP and EIDL and ERC and FFCRA and all these other programs designed to help small businesses. And in doing so, we kind of went from this defensive position to a more offensive position, and how to get ahead of these problems so our clients aren't continuously in this cycle. And a part of this offense is making sure you're complying with all new requirements, which the Corporate Transparency Act would fall under. So this affects all small businesses. There are 23 exemptions for companies that are already pretty well regulated, but for any especially small business, this is going to affect you unless you live in the Northern District of Alabama and are a member of, what is it, the NSBA? Is that right?
Yeah.
In which case you may not have to comply right now while this, all these cases are pending. But I used to always joke, so Peter and I have done, I don't know how many presentations together on PPP and ERC and all these things. And it would always, there would be some new guidance that dropped or some new rule like right before. So there was one that dropped, like the government dropped PPP guidance on the Friday before Memorial Day weekend, and we had a presentation scheduled for that Tuesday. And this is essentially the same thing, where there's brand new court case, it's 53 pages, that got, the opinion was written, a couple of days ago regarding the Corporate Transparency Act, and we obviously had this presentation. So we'll get into all of that, but for now, just know that unless you're in the Northern District of Alabama, you are still going to have to pay attention to the Corporate Transparency Act. So with all of that, I will kick it on over to Peter.
Thanks. So just so everybody can hear it, yes, we're going to send out slides. You can have access to these recordings. Additionally, you guys are using the chat. Feel free to ask questions. We'll monitor it and stop periodically. We'll have some time for Q&A at the end as well. But just to give you a little background, and then I'll take you through the court case here, so that you know that the rest of the presentation is worth listening to. So big picture, the U.S. became the world's tax haven, and there are concerns of money laundering and the ability to do some nefarious stuff behind the scenes because of the way our corporate law works. I'm a Maryland attorney. I could have a client walk in off the street and say, hey, I want to hire you to create this entity for me. I'm going to go take it and build houses or buy property, whatever it is. And he retains me, and I can go down in Maryland. It's the State Department of Assessments and Taxation. In your state, it may be, the Secretary of State, but I can go down there and I can fill out a template form that they have available that says I'm going to incorporate or I'm going to organize this entity. And its purpose, I throw in there for any legal purpose. And then, I sign as the incorporator and potentially as the initial board member or whatever may be required by the state. And I come back and sit down with my client and I say, here's the documents, the state has recognized it, you're good to go. But in nowhere is it recorded who my client is, except for my representation agreement, something internal. The state doesn't know. Now, they may know later when you go to file tax returns, if you file your tax returns correctly and you're disclosing that information. But first and foremost, they have no clue. And that is very different than how the rest of the world does this stuff, where you are identifying beneficial owners right from the go. But that's not happening, and the US fell behind. And even though there was some effort with FATCA, the Foreign Account Tax Compliance Act, dealing with financial institutions, by and large, the US just was not where the rest of the world was. And so a couple of years ago, Congress passed this law and it's going to try to make it better. This presentation and the court case that I'll talk about here in a moment is about the front end. Who has to file? What are you filing? What are my deadlines? What is it that I have to do to keep in compliance? But as you go through this presentation, keep in your mind that this is creating a database that is going to be housed at the Financial Crimes Enforcement Network, which is a bureau of the Internal Revenue Service or Department of Treasury. And there are going to be people who are going to try to access that information. And it's everybody from local law enforcement up to foreign governments. And so you can understand why some people may be apprehensive about giving this information over to the federal government to, create this database that foreign government can go and say, hey, I need this information. So that is sort of the background for why you have someone like the National Small Business United. It does business as the National Small Business Association, suing the government and the Treasury Secretary and the Director of FinCEN, saying this is unconstitutional. This organization is based in Ohio. It represents, according to the website, approximately 65,000 businesses. And so the ruling is not inconsequential in as much as it means that it's up to 65,000 of their companies are not going to be, they're not going to be doing enforcement measures to make sure they file at this point. The case itself, the judge, and I'll just read the beginning of it because I think it's really interesting. It says, the late Justice Antonin Scalia once remarked that federal judges should have a rubber stamp that says stupid but constitutional. Yet the inverse is also true. The wisdom of a policy is no guarantee of its constitutionality. And so basically the judge is saying, look, there's no enumerated power for CTA. It doesn't say in the Constitution you can require this sort of information. But there are additional clauses that are used in constitutional law all the time, mainly the necessary and proper clause. So the analysis in this case is basically working through the government's argument that says, sure, we agree it's not enumerated. There's not an enumerated power that says that we can require this, but the necessary and proper clause would save this regime, the CTA regime, because it is necessary and proper related to foreign affairs, the commerce power, or the power to tax. And in each situation, the judge goes through and considers it and says, well, it's too attenuated. The text forecloses a particular argument. Filing articles of incorporation or organization are sort of inherently a local thing. And it's using, existing case law, largely from the Supreme Court, to combat those arguments and basically come to the conclusion it's not enumerated, and the necessary and proper clause can't save it here. And so it's not constitutional. And even though there are additional arguments that CTA violates the First, Fourth, Fifth, Ninth, and 10th Amendments, they don't get to it because it's already not constitutional. So that's big picture what it's doing. The question that everybody wants to know is, well, does that mean this all falls? Nothing works. And the answer is no. One judge in the Northern District of Alabama cannot set precedent for even judges really within that same district. I assume this will be appealed. It'll go to the 11th Circuit. You may have other challenges in competing circuits, and oftentimes when you get circuit splits, it makes its way to the Supreme Court. The challenge here is sort of the timing of it, and we'll get into that. But unless you are one of the 65,000 businesses that's represented by the National Small Business Association, this still remains quite relevant to you. Any questions?
Yeah, we can go through some questions about this and like how it affects you if anyone has them. Right now, there are no open questions.
All right, so that's background in the court
Hang on, there's one
case.
question. Can you sign up with them now?
The portal's still open. You can go to FinCEN and file a BOIR is what it's called.
In
So
fact,
that's not
they told
affecting
you to continue to file. They're literally like, keep going.
Yeah. All right, so Corporate Transparency Act overview. This is just what exactly are we talking about here and what's going to be reported? There is going to be information reported about the entity itself, the beneficial owners, and we'll work through who's a beneficial owner and how they become a beneficial owner. And in some cases, company applicants. CTA became effective, the regulations became effective at the beginning of the new year. And then Rebecca mentioned this, but who's going to have to do this stuff? It was estimated that approximately 32.6 businesses that were created prior to January 1st, 2024 are going to have to file. And then the projection is approximately 5 million each year for the next 10 years are going to have to file initial reports. These are, initial reports. We'll get into it, but there's going to be updated reports and reasons that businesses are going to have to come back behind their initial report and also report again. Back to you.
So we've gotten a couple other questions since we stopped. Is how does this apply to HOAs? We will get into that when we talk about exemptions. Do you expect the IRS to really issue the penalties? Whether or not there are penalties issued, we really don't know. They'd have to know, like.
Well, it's not IRS. I'll just make that
No, for sure.
So it's not. It'll be a penalty directly from FinCEN.
But whether they actually have the ability to issue them or not, this is a huge job. It's a lot of things coming through them. I don't know how many people they have assigned.
And at this point, no deadline has passed, so we haven't seen.
Correct.
There's no reason to see any penalties at this point. The first deadline's March 31st.
And then there's a question about new businesses, and we'll get into that. So hold for now. But what is a reporting company? Generally, a reporting company is either a domestic corporation, limited liability company, or other similar entity that is created in the United States by filing some document with the Secretary of State or any similar office under the law or of state or tribe or foreign company that's registered to do business in any US state or tribe by such a filing. So the idea is normally to start a company, you go into, for us, it's Maryland, you go to SSTAT, you register your company with the State Department of Assessment and Taxation, file your articles of incorporation, and move forward. But what Peter was explaining before is that I can open a company under Peter and no one really knows about me, because he can have his name on everything, or I can hire an attorney and that attorney's name is on everything and my name's nowhere. So because of that, FinCEN is trying to understand who's the individual behind these companies, who's the individual behind these corporations. So normally, people think of exemptions as like small businesses that don't really rise to the level of needing, this kind of oversight. And this is kind of the opposite, where you're going to have oversight if you're smaller and if you are like a one-member LLC and you just hold some land, versus if you're a big company with 25 employees and have gross receipts over $5 million. So we'll get into all of that.
And just to point out, like, underlined here is filing a document, and sort of bring this back to the court case. I mean, the judge was basically like, Congress could have legislated this in a different way that it absolutely would have survived constitutional muster, because once a business really is into commerce, there's really no question that they can regulate the channels and instrumentalities of commerce. So the issue really is all they've done so far is file a document. They haven't done anything else. And so that's really what is triggering the filing requirement, and at least what this judge in the commerce context had a real issue with.
Okay, so what is not a reporting company? The following will not be reporting companies so long as they are not created by filing a document with your Secretary of State or tribe. So sole proprietorships, because you are your company, general partnership, unincorporated associations, and then any kind of trust that's for the purpose solely of like wealth planning and end of life planning. The point of that is, for those companies, you know exactly who those individuals are, right? So proprietorship is me, general partnership would be me and Peter. It's very easy to see who those folks are, because there's nothing that's preventing us. There's no barrier between me and the company, like a limited liability company or corporation, which is why they don't care about those folks. It's not a reason to become a sole proprietorship, please. There's a lot of other bad reasons why that's not okay. But that is like one benefit that a sole prop gets. There are a lot of questions coming in. I'm going to stop in a couple minutes and we can stop and answer some questions. I just think we're going to probably hit a lot of these and want to make sure that we have time to get through the material. Okay, exemptions. There are 23 exemptions for companies that do not need to comply with the Corporate Transparency Act. So, and we'll get into those in the next slide. But keep in mind, these are going to be very large companies or companies that are already very well regulated. So like utilities, banks, credit unions, things like that. The one company to kind of keep in mind here, that's an exemption, that's not something that you would normally think about, is called a large operating company, and that's exemption number 21 on our list, and employs 20 or more employees in the United States. In the prior tax year, they filed federal income tax returns with $5 million or more of gross revenue and has a physical presence in the United States. So if you have those three things, then you are exempted from this requirement. Keep in mind that requirements change, or not requirements change, but your makeup can change. And just because you're exempt today doesn't mean that you're exempt tomorrow. FinCEN is authorized to add additional entities. Each exemption must be carefully reviewed. Go to the next slide. So again, and I'm not going to go through all of these, but certain tax exempt entities, 501s, that kind of thing, are exempt because they're already going through so much regulation and restriction that they, FinCEN feels that they're sufficiently regulated and they know who's behind those companies. insurance company, you know, most of these make a lot of sense and are pretty common sense. It's just that large company that is something to think about. In an inactive entity is a term of art. So you have to look at that. It's started before 2020 and had less than $1,000 of gross receipts since, I believe, each year. So if you think you're an inactive entity, just double check and make sure that you actually fit that.
There's more to inactive. I think it's
Yeah.
6 factors or something like that. So it's not what you consider inactive.
Right.
Very specific definition.
And you know, Peter and I have like a different philosophy on these because to me, it's like, well, if you think that you're close, you're not sure, just file the thing and be done with it. What are you worried about? Just file and report. Or if you're concerned whether or not somebody's a beneficial owner or not, you can just put them on your report and move on. Whereas apparently not everyone feels as comfortable with the government as I do and doesn't want to do that all the time. And so some folks apparently are refusing to give information, and there's all these different things you kind of need to keep in mind. So we'll get into that a little bit more kind of coming through, but my advice is if you're on the bubble, just, you know, go for it and file the thing.
And I don't know
Okay.
that my advice is different. I just is maybe a little bit more realist that there are going to be people who are going to say, no, it's not a bubble thing. Tell me if I have to or not, and maybe apprehensive in the first place as well. So anyway,
Anyway,
questions?
okay, should we stop for a second and answer some questions? Or do you want to keep going?
No, we can stop.
How is a volunteer condo board considered a small business? It depends on how you file. If you file through a 501, then you are exempt. If you file through, what is it, a 528? Is that right?
Well, 501c
If you're in the 501cs.
are exempt. Section 528 HOAs would fall outside of that exemption. So devil's in the details with how your particular board was established.
Johan said, so if you join the Small Business Association, then you don't need to file. They're going to have like a run on his membership. Again, I would just file. I don't think it's worth joining an organization that has nothing to do with you. I don't know what the requirements are.
But
That's funny. I didn't think about that.
I didn't think about it either. And I saw the comment and I just said, be very, very careful. I suspect that it is not forward looking, but potentially even who was a client or a customer at the time the case was filed, not necessarily even when the opinion was rendered. I don't know the answer off the top of my head, but anybody should be very, very careful about going down that road.
Okay. Is an LLC owned solely by an IRA for investment purposes required to file? So those are like the interesting questions. It's like, if a trust owns a portion of a business and you have to kind of fight through, and we'll get into beneficial ownership, but yeah, if you don't meet these exemptions, then you would have to file.
I mean, there number 10 investment company or investment advisor is devil's in the details. I mean, you talk to us, talk to someone, do the research, figure out, you know, what the statutory authority is for these. How does it fit exactly in your company? I mean, there are going to be many of these cases that are straightforward. Somebody asked the question, is a single member LLC? Yeah, I mean, there's going to be straightforward situations like that. Then there are going to be very complicated ones where you're evaluating large employer. What's a full-time employee? How do I count that 20? You know, is you know, the gross receipts analysis, is that under section 448? You know, what do I do with refunds and allowances? You know, there's going to be challenging things with any parts of this law. So don't necessarily assume that, you know, you can come here and get all the answers because that's not going to be the case in many situations.
For sure. And we didn't, I don't know if we have a slide on this, but this is not legal advice, just for those curious. This is informational advice, educational, but by no means is direct legal advice. Okay, let's go to the next group of slides. Oh, Kenneth reviewed and said that you had to be a member as of March 1st. So the rest of you are out of luck.
So that March 1st is the date the opinion was rendered.
Yes.
Posted.
On the Friday before Tuesday.
Yes. Right after having done another one of these without.
On Thursday. Yeah, we did one on Thursday. Okay.
So what must reporting companies do? This is repeat, but again, we're going to start to get into this. They're reporting information about the entity itself, the beneficial owners, and the company applicants. So that's really the three buckets of stuff you're going to have to be figuring out. So who is a beneficial owner? This is the big question. One thing to note, a reporting company can have multiple beneficial owners. And a reporting company can have a situation where every one of its owners and every one of its employees are beneficial owners. And so we'll work through how that works. But a beneficial owner is any individual who directly or indirectly exercises substantial control over a reporting company or owns or controls at least 25% of the ownership interest of a reporting company. So right away, we've got sort of a black and white test, or at least a little bit more ascertainable, and then something that's a little bit more amorphous with substantial control. So let's get into this. Substantial control. So there's no limit on the number of individuals who can be reported for exercising substantial control. And just, again, keep in your mind, you've got the ownership test, the 25%, you've got the substantial control test, and it's either or, it's conjunctive. So you don't have to have 25% ownership and substantial control. You could just have to have substantial control. And again, that's determined directly or indirectly. And it can be a situation where an employee, a key employee, that owns absolutely none of the business or less than 25% of the business could still be determined to have substantial control because they meet some of the following criteria. So the really big one is the individual as a senior officer. So senior officer is a term of art, still challenging to necessarily figure out exactly who is in that. I mean, certainly it's the C-suite, CFO, CEO, COO, CTO, you know, any of those types of people. It's also general counsel. So an individual who holds the position of general counsel in a reporting company is a senior officer. That came out in the FAQs. But it's also an individual who has the authority to appoint or remove certain officers or a majority of the directors of the reporting company. This is when you get into reviewing articles of organization, operating agreements, bylaws, understanding on paper what someone's authority really is. Whether or not they exercise it, they could exercise it. Then you get into 3 and 4. The individual is an important decision maker. The individual has any other form of substantial control over the reporting company. And now you're really trying to determine what a day in the life is for somebody that works for this company. And
that's where you can kind of get into that, like, do you report this person? Do you not report this person? What if they're against it? What does substantial control mean? And that's kind of when you have to make a decision of like, okay, how are you going to kind of handle this?
Yep. And then so just a little bit more on substantial control, very broad. It includes what FinCEN refers to as important decision makers and certain influencers. So just think about the things that an important decision maker or an influencer could control or influence. It is business decisions, finances, structure of the business itself. Again, it is really trying to figure out a day in the life of what someone's authority is. So this is where this stuff gets hard.
This is also where you have to, if you're not an attorney, you have to be very careful in how you're giving advice to your clients. Some accounting insurance firm companies like Cameco have said that they believe this is UPL and don't want accountants getting into who is substantial control, who's an influencer, who's an important decision maker, making these kind of like legal decisions. Others
UPL,
have said it's fine.
UPL is the unauthorized practice of law.
I apologize. Yes. You don't want to get into a position if you're not an attorney of them thinking you're trying to be an attorney.
And basically, Cameco's position is sometimes the unauthorized practice of law can be considered a criminal act, and insurance companies can't insure criminal acts. That's sort of the mechanics of it. There's some other stuff about, you know, accountants being able to quote unquote read the you know, Internal Revenue Code, but this is all done not in the Internal Revenue Code. It's done in the Bank Secrecy Act.
So just something to kind of be aware of and be thoughtful of if there's stuff that you feel like it's kind of like out of your depth in giving advice or could put you in a tricky situation. That's the time to make sure that you have an attorney looking at it.
And then just quickly,
then there's the catch-all.
yeah, there's catch-all, you know, for the substantial control, it says any other form of substantial control over the reporting company. Control exercised in new and unique ways can still be substantial. And, you know, I said previously, there's situations where you could have every single owner, right? Because you have 3 owners who are at 33%, so they're automatically there. And then, you know, you have a decentralized autonomous organization where each of the employees really are empowered to, you know, participate in the management and control of the company. Well, now you have a situation where all of the owners and all of the employees are going to be required to report beneficial information. And boy, that can really feel weird to an employee who doesn't own anything. Maybe they don't feel that they have the level of control, but, you know, either through title or the way governance works within the entity, they actually do. And you're saying, you know, hey, I'm going to need to see your passport or your driver's license and, you know, remind me of your address and all that kind of stuff. It's going to feel strange. And oh, by the way, we're sending this to the Financial Crimes Enforcement Network. Also,
this is where Peter's
weird.
paranoia really shows.
That was actually part of the legal opinion where he said, you know, the government basically said, what's the big deal? You've already probably sent this information to countless other government agencies. They issued your driver's license. They issued your passport. Who cares if you're giving it back? And the court said, well, that may be true. And gave a little dig. First of all, they're like, why don't you go get it instead of making people, you know, submit it? But they also said, look, you're sending it to the criminal enforcement network, you know, another criminal type arm of the Department of Treasury. And so this is serious stuff. But there's your substantial control issues.
I think there's also talk of like, you send this like every bank where you open, in order to open a bank account as a business, you have to give all this information. So you're just giving it again. And yeah, it's the same kind of idea. Like, wow.
Yeah.
Why should I have to give it again? And how is this required? Okay, so we've got a couple more questions. Multiple single member LLCs organized with respective secretaries of state, all common owner. Employee count exempt, but how do you measure revenues? And some of the LLCs may generate less than $5 million and some generate more. Fun fact, this does not aggregate. So every single LLC is going to need to be reported unless that LLC has more employees and revenue to make it a large company. That's why we were talking to someone who is doing this like us, the Corporate Transparency Act. And I think he had a client that had like, how many LLCs?
It was
like,
hundreds.
It was so many. Yeah, I
Yeah.
want to say almost like 1,000. Like it was like, they owned so many different single member LLCs, and just like the filing of this would be so onerous. And you can't, you know, do it all as one. You'd have to do each one separately, which is a pain. For a long time, filing in Nevada was a way attractive because they didn't disclose ownership. Well, all those Nevada LLCs now have to disclose. This will probably make Nevada no longer attractive. Do you foresee Nevada suing the ruling? I think after this last opinion coming out, there's going to be a lot of litigation surrounding all of this. New York has also instituted their own version of the Corporate Transparency Act. So you're going to have, and not to get political, but I have a feeling I could see like a red state, blue state thing where blue states are going to say, give me all your information. And red states may take this opportunity to fight against it and say, you know, that this is an overreach. Who knows when it will be decided for real or how it's going to go. I mean, this has been in the works for a while. It was actually vetoed by President Trump, and then they had enough votes to overcome the veto. So that's just something that Congress agreed enough to overcome a presidential veto on this law that, you know, this might not go away. Maybe they do just change the act as far as like, instead of filing a document, it's earning your first dollar, you know, something that's more interstate commerce than just setting up your company. All right, any thoughts on board of advisor members, not formal directors and often serve on a voluntary basis? Do you have substantial control? I mean, that's the question. You're gonna have to answer that, look at your document, see who can do what, and go from there.
Just be concerned about the reference for being an influencer, right?
I mean, there's a lot of vague terms here, guys. You know, some people are called persuaders, some people are called influencers. Whether or not they want to be on the documents with FinCEN is another story. Anyway, 5 exceptions from the beneficial owner definition. So minor child, so this exception only applies if a parent or legal guardian's information is reported in lieu of the minor child's information. So when the minor child reaches the age of majority, then you'd have to update your BOI report, providing the individual's own information. Nominee, intermediary, custodian, or agent. An employee who is not a senior officer and who is simply an employee. The individual's sole economic benefit from the reporting company is as an employee. Then an inheritor and a creditor. Those are the exceptions from the beneficial ownership definition.
The inheritor and the creditor, right? Like they're really not exceptions. They're just pointing out that if you haven't inherited yet, you don't own it. If you haven't foreclosed on your claim as a creditor, you don't really own it yet. Once you do, and as soon as you actually inherit the property or foreclose on an interest as a creditor, then the clock starts ticking for CTA reporting.
Sorry, I didn't realize that there were some questions in the chat instead of the Q&A. So one question is, in a single owner LLC with no employees, is a spouse that has no role in the company considered a beneficial owner? I think that depends on the case. I mean, if they don't own any stock and have no interest in the business and aren't doing anything for the business, they can't be considered to be beneficial owner. Then no, it's not the same type of aggregation that you look at with like the employee retention credit and other types things. And then Barry says, how do I file? My lawyer wants $100 to do that. You go onto the website and file, have your documents with you, like your driver's license or passport. You're going to need that. And we'll get into that. Okay. Ownership interests. Reporting companies are required to identify all individuals who own or control at least 25% of the company. Ownership interests include equity, stock, or voting rights, a capital or profit interest, convertible instruments, options or other non-binding privileges to buy or sell any of the foregoing, any other instrument, contract, or other mechanism used to establish ownership. Is my company required to report a company applicant? So this is super fun. So for those of you that are attorneys and have a transactional practice, you've probably set up more than one LLCs in your day, maybe hundreds. What do you do? And maybe it was your secretary, Jim or Jan, who's done it for you. And like, they've set up all of your things. Do you have to report Jim or Jan, to FinCEN because they've set up these companies for every company? So you do have to report a company applicant if you are opening a new business. January 1st, 2024, you opened your business. Happy New Year. For those folks on here that know Glenn Frost, the managing partner, he texted Peter and I at 7 a.m. on New Year's Day to say Happy Corporate Transparency Act Day instead of Happy New Year. He has some issues. But so if you opened a company that day, and somebody opened it for you, then you need to report that as that person who opened it for you as a company applicant. If it's anything you've done prior in 2023 or before, then you're fine. You don't need to worry about it. Who is a company applicant? Happy CTA Day, exactly. It's literally 7 in the morning on New Year's Day.
It actually happened.
It did happen. I wish I could just like make stuff like that up, but in fact, well, I guess we have boundary issues more so than him. But anyway, who is the company applicant? A reporting company that is required to report company applicants must identify and report to FinCEN at least one company applicant and at most two. So company applicants are individuals, not companies or legal entities. So the first is the direct filer, the individual who directly filed the document that created a domestic reporting company, or the individual who directly filed the document that first registered a foreign reporting company. This individual actually physically or electronically filed the document with the Secretary of State or similar office. They push the button. The one directing, controlling the filing action. So I tell Peter to open this company and to take care of it for me. Then you need to report me and Peter, because Peter pushed the button and I directed him to do so.
All right, back to me. Again, this is the third time I'm saying it. What must be reported? It's information about the company itself, its beneficial owners, and in some cases, company applicants. So first, what are reporting companies going to be asked to do? First, full legal name of the entity, all trade names or DBAs, complete current U.S. address. So this is the principal place of business. It's a physical address. It's not a PO box or virtual mailbox, something like that. It's where's the business located. Then you have to identify the state, tribal, or foreign jurisdiction of formation. I think we might have touched on this, but I mean, this is all 50 states, District Columbia, territories, possessions, and then Indian tribes have a jurisdiction here as well. And so that's the reference to the tribal stuff that's sort of peppered throughout this, is they're making the distinction there. For a foreign reporting company only, meaning it was established in, I was talking to somebody in the UK the other day, and they then came and they said, we're going to register our foreign entity in the state of Maine, because he had a great reason. It was interesting about fundraising and building the business, but they went and registered as a foreign corporation in Maine. And so they're going to identify Maine as the first jurisdiction that they registered. They can register in subsequent ones, but you're supposed to come in and identify the first. And then the Internal Revenue Service taxpayer identification number, which could include an EIN. There are going to be situations where these businesses don't have EINs because they're single member LLCs holding a piece of property and they've never had occasion to need one. You may be in a situation where you need to additionally get an EIN in order to make the filing. So that's reporting company. Then the reporting company has to collect and report the following information about each beneficial owner. And again, there's going to be people who are apprehensive about doing this. We watched a webinar that FinCEN put on early mid-December, and they did a Q&A, and one of the questions was, well, what happens if one of my beneficial owners refuses or just, can't, or whatever? They're in a coma. They cannot get this information within time. the question was more about what if they just refuse to, but
Like
the
Peter's
best,
thought is that people aren't gonna actually like comply because people don't want the government to have license.
yeah, the best answer they really had though was like, try harder. There's not like a process for being like, hey, I'm 90% there, but Joe just won't give me his driver's license. But about each beneficial owner. So again, you can have everybody in the company theoretically be a beneficial owner. You're reporting their full legal name, date of birth, complete current address. The address here is the individual's residential street address. And there's a distinction with company applicants. We'll talk about that on the next page, next slide. And then in addition to that information, you are identifying a unique number that's coming from either a US passport, state driver's license, or state identification card. And if you don't have one of those because you're a foreign reporting company or foreign beneficial owner, your foreign passport. And it's not super hard. You're basically dragging and dropping an image into FinCEN's BOSS system, is what they call it, in order to upload this information. So there are size limitations, and you've got to think through some of those things. When I did it, I took a picture, emailed myself the document, and it wasn't really a big deal, but just be aware. Then the last category is company applicants. Again, there's only 2 of these, or up to 2, so 1 or 2, and these are somebody helped you create a company in 2024. Full legal name, date of birth, complete current address of the company applicant. In this situation, it's not the residential address. The company applicant can use their business address. But same requirement: US passport, state driver's license, or identification document from the state, or if you don't have those, a foreign passport. So that's the information that is being reported to FinCEN. There is this idea of a FinCEN identifier. A FinCEN identifier is a unique identifying number that FinCEN will issue to an individual or reporting company upon the request after the individual or reporting company provides certain information to FinCEN. So anybody who has multiple entities or anticipates opening multiple entities in the future should do this additional step. It's basically part of login.gov. So if you have any other interaction with the government, you have VA benefits or something like that, you probably already have a login.gov account. You basically log into that, create a FinCEN identifier, and it's just a unique number. And instead of having to give, so if you're an employee and you don't want your employer to know that information, that beneficial owner information, you can just give them your FinCEN identifier, and they can type that in instead of having to go through each of that information. So one additional thing to consider.
Okay, 354. So Jack, as far as like, how do you make a determination of what to do with your HOA association that is owners and no one owns 25%? Look at your bylaws, your requirements, and who can do what, and someone has to be in control. Someone has to be a beneficial owner, and if it's all 6 of you or whatever, then that's what it is. I'm gonna make sure we get through all this because the deadlines are going to be the most important thing. So first deadline is if on happy CTA day, if on January 1st you were somehow able to open a company on that day and got the registration through and all of that, your first deadline is going to be March 31st. You're going to be required to file your CTA or BOI within 90 days of opening the company. And then every day after that is a deadline. So if you opened your company on January 2nd, you're looking at April 1st, January 3rd, April 2nd. Originally it's supposed to be 30 days to file, but since this is the first year, they actually gave everyone 90 days. But starting in 2025, for all new companies, you'll only have 30 days to file. Now, for companies that were operating prior to January 1st, 2024, you have until January 1st, 2025 to file your initial BOI reports. The government isn't known for having technology that works when everyone is trying to do something at the same time. I would not give yourself like 1 day to do this. I would look at like, if you don't want to do it today, look at like October, November. Definitely don't wait until like December 30th to file your BOI, because the chances of something crashing are pretty high, in my opinion. Other key deadlines. So updated reports are due within 30 calendar days after a change occurs. So that's every time a beneficial owner updates their driver's license, gets a new, and that's a new driver's license number, not just like the expiration date or a passport number, or moves addresses or something like that, you're going to need to update your BOI. Corrected reports, if you make a mistake, you're going to file that within 30 calendar days once you know of the inaccuracy. Now, if you are helping other folks with this, you're an attorney, if you're an accountant, if you're a good friend, make sure your engagement letter is very, very clear that you're filing an initial report. Or if you're going to keep up with the monitoring, you got to make sure that you're asking your clients like every 2 weeks, any change to your BOI, because you're not going to have a lot of time. And for tax controversy clients, they would probably give me 1 day to let me know that things changed and it, want me to kind of move faster, just by the nature of the way it works. So make sure you're giving yourself plenty of time in order to file these properly. Filing process. According to FinCEN, beneficial ownership information will be stored in a secure, non-public database using rigorous information security methods and controls typically used in the federal government to protect non-classified yet sensitive information at the highest security level. So when your partner tells you they don't want to give you the information because they're worried about the security, you can repeat all of that information, and I'm sure that will ease their minds substantially. Definitely never been a breach of those systems. And these are like the sticks, right? So what if you don't report? And somebody asked earlier about penalties, and I'm sorry, it's just 3:58, and I know some folks have to go. So I'm going to pause on the questions for a second. The willful failure to report complete or updated beneficial ownership information of FinCEN, or willful provision of or attempt to provide false or fraudulent information may result in civil or criminal penalties, including penalties of up to $500 a day with no cap, or criminal penalties including imprisonment for up to 2 years and or a fine of up to $10,000.
And there are additional penalties related to the misuse of the information. Imagine, the gentleman that released Trump's tax returns, he got penalized if somebody's releasing your beneficial owner information. There's stuff there too. We've said previously that we'll send you these slides, or these are certainly available to you. The rest of this is some devil in the details. The FinCEN actually did come out with a very good small business compliance document. That's what these scenarios are from. It helps you to work through some of the reporting company substantial control and ownership information. What happens when you have direct owners and indirect owners? How does all that kind of stuff work? Again, take the time to look through it, and if you have any questions, certainly let us know. We can hang and answer some questions if.
Yeah, if people want to wait, if they've got questions, we're happy to, I think, check. I think I don't have anything. We're happy to answer questions.
Cindy, it's not an annual thing. It's when information changes that you don't know when deadlines are going to be, because you don't know when information is going to change.
There was a question, we recently applied for a loan and the lender had us fill out the beneficial owner form. Does this mean that they filed it for us? No,
I wouldn't assume so.
it
So
does
look,
not.
when you actually go and file, you get a BOIR transcript, and it has the status, and it gives you a unique number. You got a confirmation number, all these things. So unless that bank gave that to you, I would not assume they were probably collecting that information for their own reporting requirements and their requirements to know their customers.
What is the website to file?
Google and BOIR, and you'll be there real quick.
You can put it in.
I don't know what it is, but Google will get you there real quick.
Here, I'll put it in there.
My thought
And
is,
I always like, sorry, go ahead.
what if a business doesn't have a US address? A virtual address is not okay. Any business should have a principal place of business. If you don't have a US physical presence, you may not have a requirement to file. Devil's in the details. Sorry to say that again.
And just for everyone, so I normally end these webinars by explaining that, you know, Peter and I like to make sure everyone does things properly, and, you know, regardless of whether you want to hire us or not hire us to do this for you, we want to make sure you're doing it right. So feel free to reach out, ask questions. If you've got clients that are freaking out about it or have questions, you know, feel free to send them either of our contact information. We are happy to hop on a quick call and explain anything. You have to file BOIR for trusts and foundations. Not if it's for wealth planning, but if the trust owns a portion of a business or something like that, then you would have to file it for the business, and then the trust, it would like pierce the trust and go to the trustee and possible grantor and possible
Well,
beneficiary.
you've got two different ideas there. A
Yeah.
trust may not be a reporting company, but a trust could have beneficial owners involved in the trust that
Correct.
is being reported. Foundations, I mean, yeah, I believe you would create an entity with the state and then achieve your status, the foundation status through the IRS, but
All right, guys. Well, good luck with all of this. Again, if you've got questions, let us know. We're happy to help. You know, there is that first deadline that's coming up, but the others aren't for a while. I know everyone's nature is to then say, this isn't my problem today. I'll deal with this later. Just don't let December kind of creep up on you. Because I worry that everyone's going to let December creep up on them. And then we're in a position where everyone's trying to file at the same time, and it's going to be stressful. Some folks actually asked for a quick ERC update early on in the presentation. If we had time, I don't know if people are still interested in that. We'll be sending the PowerPoints, yes. Yeah, Jay Lily, yes. So as of right now, there really isn't a ton to update. The moratorium on processing returns is still very much active. Werfel testified at a closed door session a couple weeks ago in front of the House Ways and Means Committee and said that he hopes for the moratorium to be lifted in the spring, as if he has no control over that happening when he is the commissioner of the IRS. So that's possible that it could be in a few weeks. What does that mean? We're not really sure. We've seen a smattering of notices over the past 2 weeks.
yeah, a couple weeks.
2 weeks. Some of the notices say, hey, you filed a return. Please send us why you think you're eligible and the calculations behind it and things like that. It's not necessarily an IDR or an information document request. It's called the 6612, notice 6612, you can Google it. And that is something that is a little more basic, but it only gives you 30 days to respond. And the IRS is basically saying, if you don't respond in that amount of time, we are going to reject your refund claim.
Well, the 6612 is the cover page for it. I think it's an IDR. I
I don't
mean,
think it is an IDR. There's not an examiner
yeah,
listed.
it's appended to the 6612 is the IDR. At least what I saw. I could be looking at something different.
Okay.
But agreed. It could lead to a disallowance, which is unique.
Yeah, all of this is very unique, right? So there's those sets of notices, which frankly, I've been saying for a really long time, the IRS just needs to send notices out to folks and say, hey, tell me why you're eligible. And even just like see if people respond, because if they're like fake companies and stuff like that, they may not even reply. So there's another set of notices that have gone out that are more like, hey, we've received your form 941X claiming the ERC. Are you sure it's not fraud? Are you really, really sure? Do you need to report anyone for fraud? If you're entitled to this, you don't need to do anything. If you're not entitled to the refund, then you should file a withdrawal or you should file withdrawal or report your accountant. That's a really bizarre notice to send folks for filing a tax return.
And that's a CP 271. That's how that's
going. Yes. So that's kind of where we are right now. I was actually on a call right before this with Glenn, the managing partner, and he said that at a different conference, that the person in charge of the ERC program kind of said that everyone's going to get one of these like 6612s, one of these like IDRs, baby IDRs, asking to prove why you're eligible without an auditor's name on there, and without somebody you can like schedule and have a meeting with, but instead it's like a general number. So we'll see. It's an interesting time to say the least of whether or not, you know, the stuff will actually start to get processed. I will say that we've had some success in filing taxpayer advocate claims for folks that are suffering a financial hardship and waiting for their refunds. So, you know, let us know if you need help with that. We're happy to talk to you through that and what we've done and what we've been successful with.